Hello, everyone. Welcome to the third session of our Secure 2.0 Deep Dive series. I hope you all had a good holiday weekend. I'm Michael Durnwald, an attorney here in the Employee Benefits and Executive Compensation practice at Thompson Hine, and your host for this series. We have a packed schedule today, so I'll try to keep the administrative notes brief. But if you do want to ask a question during the session, look at the upper right-hand corner of your screen, and that's how you can do that. Note we'll be a little more structured today with our questions and try to organize them. We have 3 subtopics and we'll try to address questions at the end of each subtopic. And if we don't get to you, we'll try to reach out to you after the webinar and talk about that. Also, you will get a copy of the recording of today's session as well as a copy of the slides that usually will come within 2 business days. And just for clarity, know that to reduce inbox spam, the recording link will be in the same email as the invite to the next session. So it'll be sort of at the bottom of that. I had overlooked that, so I'm figuring maybe other people had as well. All right, so let's talk about our topic today. If you remember kind of at a high level, the overall purpose of Secure 2.0 is to increase Americans' retirement savings. And Congress had 90 plus different ways to try and do that. And one of the prongs that Congress is trying is they realize that sponsoring a retirement plan imposes quite the administrative burden. So some of these provisions are aimed at easing that burden, and that's what we're going to talk about today, because everybody makes mistakes, so do plans. Plans make mistakes, and these provisions are to make correcting those mistakes easier and cheaper. And so without further ado, I'm going to hand you over to David, who has fresh off the presses news because the IRS heard we were having this seminar and issued guidance in the middle of last week, and he is fully up to speed on it. So you're going to get some fresh news and insights on that as well. So take it away, David.
Thank you, Michael. As Michael said, my name is David Uhlendorff. I'm a senior managing associate in Thompson Hine's Employee Benefits and Executive Compensation Practice Group, speaking to you all today from our office in Columbus, Ohio. It's my pleasure to be talking to you about this topic today. As Michael just alluded to, I think this is a very timely topic. In one part because these provisions were effective immediately, generally speaking, but also because these correction errors or these errors and opportunities for correction happen all the time. So I'm sure many people on the call have already kind of wrestled with some of these questions and issues as they've addressed errors that have arose already this year. And also as Michael alluded to, we did get some additional IRS guidance towards the end of last week. So we have a packed agenda today, and I will not delay any further. Next slide. All right, so getting into the agenda, as Michael said, we have 3 distinct kind of provisions of Secure 2.0 that we're going to talk about this afternoon. First, and probably primarily, we're going to talk about the self-correction of operational failures. This is the area we got new guidance on just last week, so it'll probably be the majority of our discussion today, as there's lots to digest there. The second area, it deals with the overpayment and the potential recoupment of overpayments. And then finally, we have the automatic enrollment safe harbor or corrections applicable to plans that have had failures in implementing an automatic enrollment feature. So kind of diving in to our deep dive here, giving a little background on the correction landscape, what brings us here, what's come before us. So we have the EPCRS, it's the Employee Plans Compliance Resolution System. It's currently set forth in RevProc 2021-30. That's the most recent version. And generally speaking, there's 3 real avenues here for correcting plan errors that arise. Those 3 programs are the Voluntary Correction Program, or VCP, Self-Correction Program, SCP, or Audit Closing Agreement Program, Audit CAP. All these programs have, well, I'll always say that VCP and SCP have kind of different merits, different benefits, drawbacks. Typically, some errors may be eligible for both, some errors must have or are required to go through VCP. But But there are some reasons you'd want to kind of self-correct, right? There's the convenience of it. There's the virtue that you don't have to alert the IRS to an error by filing a VCP application. Outside of potential legal fees, there's no additional cost to a self-correction. Whereas voluntary correction program, you have a user fee. There's kind of a cost to admission, but the benefit of that is that you kind of hopefully aim to leave the VCP process with a compliance statement from the IRS, which is essentially your ticket to saying we've corrected this error, it's resolved. Obviously something you don't really get in self-correction program, but of course, as anyone who has addressed plan errors in the past, there are certain things that are more or less routine errors that just happen that may be more appropriate for self-correction. Audit cap is kind of the other side of this story. You don't want to be an audit cap. It's the kind of the correction for significant errors when you're under examination already. Potentially there's sanctions or additional penalties associated with it. So we definitely try to stay out of that realm. But as background, these are the three kind of avenues that were permitted to correct plan errors. So looking at what the landscape was before Secure 2.0, I've kind of dubbed this the narrows. Not that self-correction was particularly narrow before Secure 2.0, but there was certainly a broadening. And not to say that there was only narrow situations where you could self-correct before, but that there was more of a narrow path to self-correction. You had to have, X, Y, Z, and there was very step-by-step analysis on kind of how do you get to self-correction or whether you're eligible for self-correction. And those are listed here. One, you had to have established practices and procedures. Those could be formal or informal, that are designated to promote and facilitate overall compliance in form and operation. That prong kind of in practice was, generally speaking, pretty easy to get over. Most plans should have certain practices and procedures that they can point to. Certainly the engagement of a record keeper would be a good step in that direction, and record keepers typically come with their very detailed practices and procedures. So usually a pretty low bar, but a requirement nonetheless. Pre-Secure 2.0, we also had this idea of insignificant versus significant that was very fundamental into evaluating whether you were eligible for self-correction. We'll talk about that a little bit more. And there was this requirement or restriction that if the plan failure was egregious, you weren't eligible for self-correction. And egregious is really defined in the current EPCRS as generally it's extraordinary. Certain extraordinary discrimination in favor of highly compensated employees. So pretty high bar. Insignificant versus significant. This was really the crux of whether, this analysis that had to be done was whether you could get in self-correction. And the reason for that is because if your error was insignificant, there's no limited correction period. You could correct at any time. You can even use self-correction if you were under examination by the IRS. So the IRS comes and audits you, finds an error, you determine that it's insignificant, you can still self-correct. Significant errors, on the other hand, have to be corrected by the last day of the third plan year following the year of the error. It used to be the second plan year. That was a recent change. And then you cannot correct under self-correction if you're already under exam by the IRS. So some pretty, significant, for lack of a better term, differences under pre-Secure 2.0 world based on whether insignificant or significant error occurred. And insignificant errors or significant errors, the factors that you used to make that determination really had to do with amount of participants impacted, percentage of plan assets that were impacted. And again, generally speaking, you don't see a lot of significant errors. Most discrete plan errors, operational errors, you can take a pretty reasonable position that they're insignificant. But that was the structure, and that was the consequences of this insignificant versus significant. Post-Secure 2.0 eligibility, we kind of get rid of this insignificant and significant. And instead, we have this really broad broadening of correction, and that's why it's kind of titled "Headed for Open Seas." Secure 2.0 essentially provides that the self-correction period is now indefinite. It has no last day for any inadvertent eligible failure, unless there's two kind of important restrictions here. The IRS identifies the failure prior to any actions that demonstrate a specific commitment to implement a self-correction, or the plan sponsor fails to self-correct within a reasonable period after identifying the failure. So put a pin in that. Those are important phrases that we'll dig into a little bit more, but that's kind of the the first layer of restrictions. You're kind of you're in self-correction world. You have no no deadline by which you have to correct by, except for these two restrictions. If you're under examination by the IRS and you haven't already taken actions to correct, or if you discover the error and then take too long essentially to correct, you're outside of this world. So as I said, there's generally no more insignificant versus significant analysis unless under examination. That may be a little overstated. I think we're seeing how the insignificant versus significant will still come into play, and we'll talk about that maybe a little bit more when we get to the guidance that came out last week. But also one of the ways that insignificant versus significant appears to still live is kind of under examination. And again, we'll talk about this more, I think, in a few future slides. But in addition to that, there are some other pre-secure 2.0 requirements that are retained. So when you're self-correcting an eligible inadvertent failure, you still have to have established practices and procedures. We just talked about that a slide or two ago. Formal, informal, it retains that requirement. In order to self-correct, kind of pursuant to this guidance, you have to have these practices and procedures. It's still unavailable for egregious errors. Now it's also unavailable, kind of it's an expansion of this idea, for any failures that relate to the diversion or misuse of plan assets, or failures directly or indirectly related to an abusive tax avoidance transaction. So again, hopefully those are pretty limited circumstances, but that's kind of a pre-secure 2.0 idea that's retained. And then errors must be corrected in conformity with the general principles that apply to corrections under the code and related guidance. We'll talk about those in a little bit, but Secure 2.0, or excuse me, EPCRS already has reflected in RevProc 2021-30 these general principles that correction, whatever correction method you use has to comply with those. So it kind of relies on those as well still. And then there's this interesting thing in Secure 2.0 where it also explicitly calls out correction of certain loan errors and references a relevant provision in current EPCRS and says, any loan errors that are eligible inadvertent failures, they can also be now corrected under this self-correction, kind of new self-correction regime. There's also specific instruction to the DOL that they need to respect or observe the new kind of self-correction methodology, but obviously still retains the reporting or procedure requirements that DOL can impose. So I think in this context, if you have a loan error, sometimes you also have a prohibited transaction issue that needs to be addressed through the voluntary fiduciary correction program. But yeah, so loans are explicitly pulled into this kind of world, or loan errors, I should say, are explicitly pulled into this world as well. So I left this slide in here. You can imagine with the guidance that came out, I think it was Thursday the 25th, much of this presentation had been put together already. And one of the things I was going to talk to you all about is all these open questions and opportunities for guidance that we're going to get. And I thought it was useful to kind of leave those in there and highlight where the gaps were and where might the IRS provide additional guidance before we get into that additional guidance. But just reading Secure 2.0, you kind of scratch your head and you say, what is an eligible inadvertent failure? It's really broad. It's a failure that really is, as long as it's not basically detected by the IRS and under examination, or that it's corrected within a reasonable time. But does that really tell us everything? Is it really as it really comes down to how narrow or broadly the IRS will interpret it. And so far, I think, and based on the language of Secure 2.0, I think it's pretty broad. But looking for more kind of additional guidance to make sure that's consistent, or to kind of give some kind of warning that IRS maybe will interpret this a little more narrowly than we might have anticipated. Because again, a lot of this guidance is being relied on now for errors that have occurred. Another two big items I think that were questions after the just Secure 2.0 language is, what are actions that demonstrate a specific commitment to implement self-correction? What actions do I have to have taken as a planned fiduciary to correct before the IRS comes in and says you're under examination, for me to still be kind of protected under this eligible inadvertent failure correction kind of regime? And then what is a reasonable period for self-correction? To be eligible for this correction methodology, you have to correct within a reasonable period. Again, that was just kind of an open item. No one really knew what reasonable meant. So Secure 2.0 calls for updated EPCRS guidance by December 29th, 2024. And that's really the deadline, I think, by which we anticipate a new RevProc to be released and kind of build in all these different correction kind of expansions or modifications in some circumstances. So that's kind of what we're waiting for long term. But in the meantime, as what we've seen, we expected and still expect the IRS to kind of release more targeted piecemeal pieces of guidance that address questions that have been have been raised with the regulators to say, listen, this Secure 2.0 provision is pretty broad and we're trying to implement it, but we really need some additional guidance, and it's maybe potentially effective now, or in the case of some of these other Secure 2.0 provisions, it's going to be effective next year, and we're trying to administer it, but we need additional guidance. And so we finally got our first piece of piecemeal guidance from the IRS in that regard. That came out last Thursday, released May 25th, 2023, in the form of IRS Notice 2023-43. Again, it is limited interim guidance. It addresses certain questions, very limited questions in the form of Q&A. It only relates to questions in this kind of self-correction of operational failures. It does not relate to any of the topics that we will also be addressing in the other two kind of portions of this webinar. There is a request for comments by August 23rd, 2023. So, potentially there's some follow-up there. Maybe there's some tweaks. But in the meantime, the IRS notice kind of states that we can rely on this. We can apply this in a good faith, reasonable interpretation as we correct errors that we're dealing with currently. So I think it's helpful. Let's go through the Q&As. We'll go through each of the ones that are relevant to kind of retirement plans. There's a Q&A relevant to IRAs. We're not going to touch down that just because I think our focus today is on employer qualified plans. So our first question, can plans correct eligible inadvertent failures before EPCRS is updated? So we have, Secure 2.0 effective date says it's effective immediately, but we don't have EPCRS. We have things within EPCRS right now that may no longer apply. Before we get our new RevProc, can we use this guidance to correct? Yes, we can, provided that, and then this is kind of a regurgitation of and an expansion, I think, in some ways, the kind of all the requirements are in Secure 2.0 kind of synthesized in an easy list. So yes, you can correct these eligible inadvertent failures before EPCRS is updated, provided that the failure is not identified by the IRS prior to any actions demonstrating a specific commitment to implement a self-correction. We've already addressed that. Self-correction is completed within a reasonable period after eligible inadvertent failure is discovered. Again, already discussed that. The failure is not egregious, abusive, or relating to diversion or misuse. And again, these are kind of our touchstones of that were already set forth in Secure 2.0, just restated in this kind of Q&A to say, yes, you can rely on the guidance, but you still need to meet these requirements. And in some of the additional future Q&As that we'll discuss, kind of unpacks these. So the kind of the fourth bullet of this requirements of how you can implement this kind of correction is this kind of umbrella term of it generally satisfies current EPCRS provisions, other than those provisions that no longer apply, which we'll talk about those. But then it lists these current EPCRS guidance that you can kind of go to REVPROC 2021-30 right now and take a look at, including these practices and procedures requirement that we've talked about, following the rules of general applicability per section 6 of REVPROC 2021-30. If you look that up, it'll talk about, you know, this concept of restoring a participant to the same position that they would have been in had the failure not occurred. That's kind of always the guiding principle when you're implementing a correction. We want to make sure that the correction methodology is reasonable and appropriate, consistent, that that you're treating similarly impacted individuals the same, et cetera. So there's a list of those kind of guiding principles. Those are all still rules of general applicability that are even under the new eligible inadvertent failure. That's still our guiding principle for self-correction. The third one, plan sponsors are permitted to use methods that are included in appendices A and B, not required to. If you're familiar with how REVPROC 2021-30 reads now, and you know that there are 2 appendices in the back that really provide specific examples for, I'll say, commonly occurring plan errors. They can be extraordinarily helpful. They kind of build off of these general rules of general applicability that we just talked about. Those are still in play. Those are still kind of, again, the guiding principle that your correction methodology should follow when you're self-correcting these eligible inadvertent failures. This other side of that coin is that it cannot be prohibited under REVPROC 2021-30. So just from that, I think it's helpful to think of this as, it truly is a broadening of correction. It is kind of a new world of correction, but it still retains a lot of the old, and there's still, it's not a complete rewrite, I guess, of the self-correction rules that we've used in the past. So are there any eligible inadvertent failures that a plan sponsor may not correct? Yes, and hopefully they give us a complete list of errors that cannot be corrected as eligible inadvertent failures. Those include failure to initially adopt a written plan, a failure that occurs in an orphan plan, so one where it's kind of been abandoned by a sponsor, a significant failure in a terminated plan. Again, I would, going back a couple slides where this world of significant versus insignificant may have been reduced because we're not really evaluating that unless we're under audit as our way to get into self-correction. But here's another way it shows up. If you have a terminated plan and there's a significant failure that's occurred, you can't self-correct under this new guidance. Demographic failures, so think about your non-discrimination requirements, unless they're corrected pursuant to applicable regulations. And I should say these errors are errors, I think they're appropriately excluded because they have very specific correction methodologies kind of set forth currently in EPCRS. So this this carves out demographic failures unless there's those demographic failures are corrected pursuant to applicable regulations. There's hard-coded regulations for compliance testing failures that you can fix those errors when you test and you get a negative result. You can fix those, but if you're correcting them somehow outside of that regulation, then you're not eligible for this self-correction. And then lastly, an operational failure corrected via plan amendment in a manner that is less favorable than original terms of plan. I think that's going to be a pretty narrow circumstance as well, but I guess you could foresee potentially an operational error that existed because the plan wasn't properly amended to reduce a benefit, but maybe there was sufficient participant communications provided that reduced that benefit prospectively, that reasonably kind of showed the intent and that the communication was there. Maybe there's a way you can self-correct that, but this is saying, in general, if you're reducing or I shouldn't say self-correct, that you can apply for VCP. This is saying if you kind of correct that way, if you're doing a retroactive amendment that is any less favorable than what's in the plan, you're not going to be able to go through self-correction. You have to find a different way to correct. But that wouldn't apply necessarily to an operational failure that was corrected by a plan amendment or retroactively that was more favorable, for example. So those are the 5 kind of errors that are excluded or prohibited from self-correction under this new guidance. So are there any EPCRS provisions that no longer apply to self-correction of eligible inadvertent failures? This is kind of a preview, I think, of what our new RevProc will look like. Some of these provisions will be removed. Yes, there are kind of now dead provisions, I'll call them, in the EPCRS. They're currently reflected in RevProc 2021-30. They include the favorable letter requirement. You're no longer required to have a favorable determination letter to self-correct certain errors. You're no longer prohibited from self-correcting of demographic and employer eligibility failures and certain loan failures. Obviously, we just discussed how those could potentially be self-corrected. So the kind of the blanket prohibition is no longer applicable. And then provisions relating to self-corrections of significant failures that have been substantially completed before examination or by the end of the 3rd year following the year in which the failure occurred. That provision is obviously no longer applicable. You have this much broader kind of regime of no correction period or an infinite correction period, provided that the other requirements are met. And instead of this kind of idea, there's language in current EPCRS that basically talks about if you've substantially completed a correction by the end of the 3rd year following the year in which error occurred, even if the error is corrected kind of and maybe it hangs over a little bit in that 4th year, well, there's guidance that says you've substantially completed it. So that's gone now. We're really in this world of have you shown enough action that is committing to the self-correction, essentially. So a couple quick hits. When is an eligible inadvertent failure treated as having been identified by IRS and no longer eligible for self-correction? It kind of regurgitates what Secure 2.0 says. It says when the plan comes under examination, but kind of references EPCRS. EPCRS essentially defines, when a plan is under examination as when they receive notice that an examination has occurred. So you receive a letter from the IRS saying you're under examination. Upon receipt, you're under examination, and kind of you have to consider significant versus insignificant. And then, can a plan sponsor use self-correction to correct an insignificant failure, including an eligible inadvertent failure, when the plan is under examination? Yes, and I think there was it's a little confusing the way Secure 2.0 reads, because essentially it says you have this eligible inadvertent failure, self-correction ability if you show that you're correct, you're committed to correcting it before you're under examination. Well, then it's also saying, well, no, if it's insignificant, even if you're under examination, which again was the prior rule, that's still the prior rule. Like if it's determined to be insignificant, you're not going to be precluded from self-correcting even if you are under examination. So before EPCRS is updated, how will actions taken by a plan sponsor demonstrate a specific commitment to implement the self-correction of an eligible inadvertent failure be determined? So this is kind of one of those number 1 questions, I think 1 and 2 of coming from Secure 2.0. It seems like a pretty important phrase that didn't really have a definition. And of course, in IRS fashion, we don't really get a clear definition. Instead, we get a facts and circumstances based test, which is not unusual. Helpfully though, this new guidance does provide that IRS is going to be looking at whether you're quote unquote actively pursuing correction, and then gives us a little bit more guidance and says mere completion of an annual compliance audit or adoption of a general statement of intent to correct failures when they are discovered are not actions demonstrating a specific commitment to implement the self-correction of an identified failure. So if you identify a failure, and the IRS comes in for audit, you can't say, well, this is a significant error, but we've demonstrated that we're actively pursuing this correction because we have a general policy that we intend to correct all errors, for example. That's not going to be enough. Before EPCRS is updated, how will a reasonable period be determined? Again, we get a facts and circumstances based test. This one gives a little bit more by way of parameters, except for employer eligibility failures. And those are not very common errors. Those are employer eligibility failures are essentially an employer who is otherwise not eligible to adopt the type of plan that they're adopting, that they adopt and they discover, oh, we weren't actually, the tax law doesn't permit us as this style of employer. I think if you're a governmental employer, we can't adopt this 401k plan, for example. That's kind of carved in its own bucket, but the general rule is that the eligible inadvertent failure has to be corrected by the last day of the 18th month following the date the failure is identified. That's going to be treated as timely. So you discover it, day one starts, by 18 months later, you have to have that correction, that correction completed. For these employer eligibility failures, it's going to only be treated as timely if all contributions are ceased. Again, kind of given the nature of the error, I think that makes sense. It's only going to be treated as timely as if contributions are ceased as soon as reasonably practical and in no event later than the last day of the 6 months. So a much shorter runway to get those kind of errors self-corrected. Okay, a couple more questions here that were addressed in IRS Notice 2023-43. Is the plan sponsor prevented from self-correction of a failure for failures that occurred before December 29, 2022? December 29, 2022, of course, being the date that SECURE 2.0 was signed into law. No, this is not this is not limited to errors that arose after SECURE 2.0 was passed. These are applicable for errors that are being corrected now, even if they go back years. And then this Q&A, may a plan sponsor submit a VCP for an eligible inadvertent failure? Yes, you can almost always go for VCP. And again, back to kind of our first slide or two, there might be reasons you want to still going for VCP. Maybe you have a novel correction, novel failure, novel correction that you want to propose and get it blessed. Maybe this is just a unique error that doesn't really have a clean, kind of a clean example in EPCRS currently. So that option, that avenue to correction is still available for eligible inadvertent failures. And then just a couple more. Does self-correction of an eligible inadvertent failure for which an excise or additional tax is due automatically waive such tax? No. If you have a correction that if you have a correction methodology that the underlying error produces or causes the taxpayer to incur an excise or additional tax, and there's some avenue for waiver, they still have to apply for that waiver. This doesn't change anything to say, well, now we have a broader correction, so this tax that used to be subject to is waived automatically. No. I think a good example of this is RMDs. Correction, you have a late RMD, the correction method generally, you're gonna have to distribute those RMDs out, right? But there's still this excise tax that might apply, and there's this process by which you can ask the IRS to waive. That's still the same case. You correct the RMD, it's a self-correction because it's an eligible inadvertent failure. You still have to go in and submit the appropriate application to get the waiver of the tax. And then I think the last Q&A here, I think this one's actually pretty helpful. Does SECURE 2.0 impose additional record-keeping requirements for these types of failures? No, but current record-keeping requirements continue to apply. I think one of the questions that we saw after SECURE 2.0 was, well, are you still going to have to kind of document self-correction activity in the event of audit? There's this requirement that if you're audited, the auditor is gonna ask you, you had this error, where's your self-correction memo that tells me what the error was, who was impacted, how much plan assets were impacted, date of correction, how you corrected, what part of EPCRS are you relying on, things like that. So that very much still applies. So wrapping up on the self-correction of operational failure section, I think it's helpful to just walk through a quick example here to more or less illustrate, I think hopefully both the difference between pre and post Secure 2.0, as well as kind of some of the uncertainty that still exists even despite this, additional guidance that we got last week. So we have a plan. It experiences an operational failure in December 2019. The plan discovers the failure in January of 2023 and determines the failure is significant. I know I said, significant errors are not as common occurrences, obviously, but in this case, for the purpose of this example, we're accepting that this determination is made and it's a significant error. It's a real whopper. Under the prior rules, the failure would have to be corrected through VCP, right? Because we had this failure in December of 2019 that starts the third year following the year in which the plan or which the error occurred. So that gives us 20, 21, 22. We didn't discover it till January 2023. We're outside of self-correction because it's a significant error. But now, post Secure 2.0, self-correction may still be available, right? Because we're not beholden to this 3-year requirement. It's an infinite period. Again, assuming those other requirements are met, we have policies and procedures, yada, yada. So the next fact, plan sponsor prepares a spreadsheet of impacted participants and amounts with a description of the error with the intention of sending to outside counsel for advice on how to correct. Maybe you have a benefits manager receives from a benefits analyst, says, hey, I think we have this error. Benefits manager says, okay, let's get a scope together so we can send it all in one email to our outside counsel and get their take on how we should correct. Unfortunately, before sending the spreadsheet to counsel, the plan sponsor receives an audit letter from the IRS. Maybe a participant alerted them that there's an error. They got, they were damaged by some error from the plan that the plan didn't catch, but instead of the participant going to the plan, maybe the participant went straight to the IRS. Who knows how these things, what really prompts these types of letters, but nevertheless, they get these letters. They get this letter before they send kind of the scope of the error to outside counsel. We're left with this question of, is the scoping of the error sufficient to demonstrate a specific commitment to implement a self-correction? And that would enable us to get still into self-correction, right? Or is the plan sponsor stuck with audit cap because we have a significant error and now we're under examination? I think the answer is I don't know. I think this is kind of designed to illustrate the still ambiguity we have. I think, can an argument be made that this was demonstrating a specific commitment to implement a self-correction? I think certainly. Going back to the kind of language, is it more than a mere general statement of intent to correct? Possibly. Could it be in kind of, could this guidance result in changes in how we communicate plan errors? Potentially. I think we could see that it would be a good practice to adopt going forward to say, as soon as an error is identified, even while you're still scoping it, when you're communicating about this error with counsel or even internally, communicating that intent to correct. So we need this information as our first step towards correction of this error, for example. It remains to be seen whether things like that would carry the day with the IRS in making their facts and circumstances analysis, but I think it certainly couldn't hurt. So before moving on to the next topic, the overpayment and recoupment, I'll pause for a moment, Michael, to see if there are any audience questions to be addressed.
Congratulations, David. You managed to answer all the questions that came in during your talk so far.
Excellent. That's what I aim for. Okay, great. So then we'll move to our next topic. Okay, next slide, Michael, thanks. So overpayment and recoupment, we're outside of eligible inadvertent failure talk. We're now firmly in overpayment recoupment. Again, the recent guidance we got last week does not address this. So this is pure Secure 2.0 and post Secure 2.0 kind of information and in some ways speculation on how things will be interpreted. I've labeled this the white whale problem. If you've been following along to the subtitles, you may have noticed I may have gone a little bit overboard with some of these puns that relate to our deep dive series, so apologies for that. But I think this is kind of a descriptor, appropriate descriptor for this, because it really describes what it was like for pre-Secure 2.0 correction of overpayments. We have this, here's an example I think that illustrates this issue that we've had. We have a pension plan, we have an error, it results in an annuity payments that are higher than what they should be. So we have an overpayment. EPCRs would permit the plan to seek repayment by the participant, by repayment or by offset of future annuity payments. If the amount is not recouped, the plan sponsor would be on the hook to kind of restore the plan. Generally speaking, there was this exception for plans, defined benefit plans that had an AFTAP of over 100%. But that was kind of the landscape. It's an overpayment. You can go after it. I think more recently, and we can go to the next slide, Michael. We've seen this trend from it being a requirement to recoup to more of an optional thing, in recognition that this is a very difficult thing to do in practice sometimes. Thinking, even in a 401k plan, you have you have an excess deferral to someone, and then they terminate employment, they take their money with them, it becomes kind of an overpayment to that individual. Well, they're no longer your employee, you no longer have access to those amounts, you discover later it's an overpayment. What are the chances that I'm going to locate this individual and that they're going to write me a check? Probably not high. But as we just said, there's this requirement that if the amounts were not recouped, generally the plan's going to have to be made whole. So not only is the plan out the overpayment, now the plan sponsor, I should say, and is out the overpayment, they are now required to put that amount into the plan to make it whole. So we almost have this like double impact. And then in addition to this, even if we decide not to recoup it, maybe it's a really small overpayment, maybe slightly more than the de minimis overpayment amounts that are in EPCRS. We decide not to recoup it, but we still have to provide this notice to the impacted participant that says, hey, we're not coming after you for this money, but the money you took, or the money that we gave to you and that you took in a distribution, it's not actually eligible for a tax favored treatment because there's more than the plan permitted you to receive. And then they have to figure that out, right? Maybe they've rolled it over to an IRA, and then it's kind of an individual taxpayer issue. But you see how there's these practical challenges with the way we've corrected overpayments in the past, difficult to recoup, and kind of punitive impact to the plan, kind of this double impact. But thankfully we have Secure 2.0 that's kind of changed this slightly. So the headline, I think, of this, of Secure 2.0, was no longer required to seek recovery of overpayments subject to these requirements. I've said this is more of a catch and release approach, right? You catch the error and then you can let them go. You're no longer required to seek the recovery of overpayments. You're no longer required to restore the plan, except for these important kind of bullets here. In the case of DB plans, you don't have to seek recovery of the overpayment, except when the failure to do so would materially affect the ability to pay benefits. So if you have an overpayment that is so large that it affects your funding status, then yeah, maybe you should have to seek to recover the overpayment or otherwise make the plan whole. In the case of DC plans, you don't have to seek recovery of overpayments, provided that any impermissible forfeitures are restored. I think this might come up in a circumstance where, let's take a 401k plan, for example, may have a profit sharing contribution, maybe the allocation formula, which is, I don't think this is typical, but if you had we had $1 million of profit this year, it's going to be contributed to the plan. Each participant gets a pro rata portion of that profit sharing contribution. Well, if you accidentally paid one participant more than they should have been, then just by virtue of the formula, that means you paid the other participants a little bit less than they should have. And in that case, that's an impermissible forfeiture. So in that case, you'd either have to seek recovery of overpayment, or more likely, you're restoring those forfeitures that occurred by making it, the other participants whole through another contribution. The other piece is you're no longer required to seek recovery of overpayment unless the overpayment is the result of a fiduciary breach, which seems could be significantly limiting, but we have this caveat that's built in. It says, provided that a breach will not arise if the plan has established prudent procedures to prevent and minimize overpayments, and the plan fiduciaries have followed such procedures. So again, going back to this kind of idea that we want to at least make sure there are procedures in place and that generally they're being followed. But like an inadvertent failure to follow those procedures, or despite those procedures, this mistake or error occurring, is not going to prevent you from kind of taking advantage of this new guidance that says I don't have to go after that amount or make the plan whole. And then very helpfully, it also provides that any overpayment will be treated as an eligible rollover distribution. So that means there's no notice required. So now we have that example that I said where we have an excess deferral, the participant leaves. Now we don't have to even send them a notice to say the amount you took that is an overpayment under EPCRS. We don't have to send them that notice to say that that amount is not eligible for favorable tax treatment, because it is. It's going to be treated as an eligible rollover distribution, just like it was. We can just kind of, again, we caught the error. Let's document how we're correcting it under this new guidance, but we can kind of just let it go. So here's where it gets very, very interesting. There is part of the Secure 2.0, it says you don't have to recoup, but you may recoup. There could be scenarios that we can imagine where a plan sponsor would want to recoup those amounts that it overpays. Here's a laundry list of restrictions that apply to your efforts to recoup. So maybe a little misleading that this presentation is called easier corrections and recoupment, because in fact, if the recoupment is the path that you decide to go down, there are now, I would say, pretty significant limitations on how you can do that were not applicable before. So let's go through them. First one, no interest or other additional amounts. So no collection costs may be sought when you're seeking the overpayment. Limits on amounts recouped from non-decreasing annuity payments. There's these very specific rules that are mathematical in nature to say, if you decide to recoup from a non-decreasing annuity payment, then we're going to limit the amount and the speed, basically, with which you can recover that amount. You can imagine that if someone was relying on a non-decreasing annuity payment as a retirement, it's kind of their budget, right? Every month I get this check, and that's what I live on. And then you get a notice saying, we've actually just discovered we've overpaid you for 2 years, and we're going to seek to recoup that all from your next payment, and reducing that payment to practically nothing, or actually reducing the next several payments to nothing. You can't do that. No more than 10% of the full dollar amount of the overpayment may be recovered in a calendar year. Future benefit payments are not reduced to below 90% of the otherwise payable periodic amount. And then any reduction would cease when full recovery is made. So pretty strict requirements on any overpayments that are sought from non-decreasing annuity form of benefit. There's also this provision that says if the plan is seeking to recoup past overpayments of a benefit other than a non-decreasing annuity, so think lump sum, think a decreasing annuity, the plan satisfies requirements developed by the DOL. Well, we don't have any requirements under the DOL. So how are plans supposed to satisfy those requirements that are developed by the DOL to correct, for example, lump sum overpayments with DOL correction pending? A very literal reading of this and could be that correction or recoupment of overpayments for lump sums, for example, is not permitted because you can't comply with requirements that don't exist. I think there's another reading, and given some of the good faith interpretation language that we have, I think there's another reading that says, well, when or if the DOL comes out with these requirements, they would have to be complied with. In the meantime, we kind of live with all these other ones, and whereas pre-Secure 2.0, we were permitted to seek overpayments for lump sums, for example, we can continue to do so, subject to these other requirements. Three more. So there's no threats of litigation unless there's a reasonable likelihood of success to recover an amount greater than the cost of recovery. So that's a pretty high bar, I think, before you can threaten litigation to recoup. You cannot use collection agency unless the participant or beneficiary is in default of a settlement or final court order requiring repayment. So in the event you actually get a court order that says they need to repay, and then they're in default of that settlement order or the court order, then maybe there's a collection agency option, but until then, that's off the table. Also, overpayment to a participant cannot be collected from a participant's beneficiary, including a spouse, surviving spouse, former spouse, or other beneficiary. I think we'll see this one in our example that we'll go through. I think this one could come into play more than some of the other ones and could be somewhat limiting. And then finally, our last kind of three restrictions on recoupment. Recoupment may not be sought if first overpayment is more than 3 years before written notice of the overpayment is provided, except in the case of fraud or misrepresentation. So we have this clock that starts going as soon as we make the overpayment. If we discover that overpayment and don't communicate that overpayment to the individual, within the 3 years from that from the overpayment began, then we're outside of this. We can't recoup unless there's a reason that the participant is, responsible, essentially, through fraud or misrepresentation. The participant and/or beneficiary can contest recoupment via the plan's claims and procedures. So this is less of a limitation on your ability to recoup, but more of a, if you're recouping, you have to let a participant make use the plan's claims procedures to make their case, to make a claim that they're entitled to this benefit, either that the benefit was calculated correctly or potentially that one of these exceptions applies that would preclude the plan from recouping. And then finally, this is not really a restriction either, but Secure 2.0 does say, in determining the amount of recoupment, the plan sponsor may consider the hardship that is likely to be imposed. So it may consider the hardship likely to be imposed. It's a pretty innocuous, I guess, provision. I'm not sure, what level of consideration will be expected to be given, but I could see maybe a scenario where you go out, a plan sponsor would recoup a portion of what they're of the overpayment and not the whole amount because they're kind of considering this hardship, but that still kind of would be subject to these otherwise limiting factors. So those are the kind of the 9 things that apply if you're recouping, if you're trying to recoup an overpayment. But as we'll see on the next slide, there is a significant kind of add-on to this. Everything I just talked about, except the claims and appeals procedures or the hardship consideration piece, that is rendered moot. That is does not apply if a participant is quote unquote culpable. So pretty important that we find out what it means for a participant or beneficiary to be culpable. Secure 2.0 says you're culpable if the individual bears responsibility for the overpayment, such as through misrepresentations or omissions that led to the overpayment. So kind of a lower bar than that fraud misstatement that we talked about, applicable to the 3-year. Do we know what misrepresentation or omission, when does that arise to being culpable? I'm not sure we do. Or the individual knew the benefit payment or payments were materially in excess of the correct amount. So they got a huge paycheck or a huge benefit check, and they should have known on its face that it was materially in excess of what they were owed. But the Secure 2.0 is clear. It's not merely because the individual believes the benefit payment or payments were or might be in excess of the correct amount if the individual raised the question and was told by an authorized plan representative that such payments were not in excess of the correct amount. So kind of interesting, it says, if they should have known and it's so materially above what they should have been owed, then maybe they're culpable. But you can't say, well, they knew about it because they actually asked about if their benefit was correct. But actually, our plan representative told them that the payment was correct, and So that was our bad, but they're still culpable because they should have known. No, that's not going to get you there as far as being able to ignore these restrictions and otherwise recoup. So a little bit of uncharted waters here in overpayment correction, I think. I think this example will exhibit that somewhat. We have a pension plan that's making annuity payments to a retired participant who selected a 50% joint survivor form of payment. Participant dies in January 2023. The pension plan is unaware of the participant's death and continues to make 100% annuity payments, the participant's amount, for 3 whole months before the participant's spouse reports the death. Checks are made via direct deposit. So you can imagine a scenario where someone has just lost their spouse. They may be dealing with estate, things of that nature, but they haven't checked this account. And over the 3 months, there are direct deposit checks going into this account, unbeknownst to the spouse. Well, is that going to arise to a culpable spouse? I'm not sure that it would. And then going further, the surviving spouse is also the participant's beneficiary under the plan and to the participant's estate, which includes the 3 months of 100% annuity payments. So we have this rule that says we cannot collect overpayments to a participant from that participant's beneficiary unless they're culpable. And so could a pension plan in this situation recover that overpayment to the participant from the participant's beneficiary via offset of, in this circumstance, 50% JNS, so the survivor portion would begin to the spouse? Could they reduce that by the overpayment that had just occurred earlier if they determine that he or she is culpable? I think there'd be kind of some risk in doing so. You start looking at it, and maybe it's a facts and circumstances based analysis where, maybe three months looks a little more forgivable, whereas 9 months, 12 months, maybe that looks a little less forgivable, a little more culpable. We just don't have any more information, I think, to really know for sure. Although I know, anecdotally that these things have to be administered in the meantime, and some record keepers are taking the position that would render someone culpable. So something to keep an eye out for, making sure that your overpayment recoupment policy is kind of updated to reflect these new rules would be very important, and kind of evaluate whether you want to be maybe a little bit more aggressive, building in some of these kind of deeming someone to be culpable. So more to come on that. I'm sure that we'll have additional guidance in the future, but that's kind of where we are. And for the sake of time, I think we'll move right to our automatic enrollment safe harbor provision. And then if there are any questions, we can address them then, but I want to get to this. So we have this automatic enrollment safe harbor provision in Secure 2.0. It is technically effective, for next year, but like the other 2 topics we just talked about, it's something that kind of is in effect now, honestly, because it is mirrored after something that we have currently in EPCRS that has been renewed several times, but it always has kind of a sunset provision, and it was set to expire at the end of this year, at which time this new rule will permanently replace it. And what this is a safe harbor correction method that is available for reasonable administrative errors that are made with respect to implementing automatic enrollment, automatic escalation, or failing to offer an affirmative election due to the employer's improper exclusion from the plan, provided that the error is corrected within the earlier of 9.5 months following the end of the plan year in which the error occurred, or if the participant notifies the plan sponsor of the error the last day of the month following the month in which such notice occurred. The error is corrected for all similarly situated participants in a non-discriminatory manner. There's this very important notice requirement that has very specific things that need to be included in it, and that has to be provided no later than 45 days following the date on which correct deferrals begin, not when necessarily when you discover the error, or when you're kind of this 9.5 month period restriction. They're kind of different timelines, and sometimes people will correct the error, notify. Or excuse me, they'll start correct deferrals, but then say, how do we fix this to correct going back? It's like, well, your 45 days clock's already started running on when the correct deferrals begin, so our hands are tied. And the benefit to this safe harbor correction is that you don't have to make any QNEX for the missed deferral. As long as you follow these requirements or meet these requirements and make missed matching contributions plus earnings to the participant's account. So kind of the safe harbor gets you out of making QNext for the missed deferral opportunity. That's the benefit of it. And another thing that I think was missed by some in Secure 2.0, and it was a debated topic previously Secure 2.0, and maybe there could be some debate whether this doesn't apply till next year, but the correction may occur before or after the participant has terminated employment and may occur without regard to whether the error is identified by the IRS. Previously, there was this idea that because we couldn't provide a notice that met all the requirements of the notice to a employee that had terminated, because they had terminated, this new guidance says actually you can. So you can treat everyone the same whether they've terminated since the error or not. So again, this is kind of an effective now, even if it says the effective date is not until next year. So those are the three correction areas under Secure 2.0. I hope this was helpful. Michael, I know there may be some questions. Given the time, we can follow up with those individuals after the webinar.
Yep, that's correct. Don't want to keep anybody sort of after class.
Great.
So we'll follow up with you if David didn't answer your question in his prepared remarks. Thank you for joining us today. The next webinar is June 28th, and we'll talk about the glamorous Secure 2.0 provision that got all the headlines, which is the student loan match. You'll get an invite within 2 business days of this webinar with the invite, and that will also include the recording and the slides from today. And until next time, have a good month.